Hello everyone. So today we are going to start our professional responsibility NCA course. So in this lecture 1, I'll be covering two topics. Number 1, professions and professionalism, the profession of law and law as a profession. Number 2, that is the second topic under part A, regulation of lawyers and regulation of the legal profession. So in this course, we will be covering each and every aspect starting from word meaning, what is the essence of any line, any case, any article, and how we have to implement that concept in our examination. So now let's start. So firstly, let's look into the schedule of this course. So NCA Professional Responsibility course starting from 1st June will go till 23rd June. So you can see 1st June I'll be taking up the first video lecture in which there will be these two topics. Then after lecture video, you have to follow my practice questions, notes. Then 6th June, next topic, then 10th June. So after 10th June from 11 to 14, when once we are done with part A and part B. So I will assign you questions scenario based exactly the kind of questions that you will be going to get in exam. So I will check your answers, will give you feedback. So proper feedback will be discussed personally with you as well as I'll be discussing in the last detailed answer writing session. So I will be providing you feedback on each single line so that you can get an idea as where you are lacking, what are your strong areas, where you need to improve. So based on solved sample paper that I have shared with you with the notes, so you will be writing answers. So in the IRAC form. So answer writing practice session 1 will be from 11 to 14 June. Then 15 June, I'll start with another lecture that is part C. Then 18 June, 20th June. So 20th June will be the last video lecture. So here we will be completing all four parts of professional responsibility. Then second answer writing session. From 21st to 23rd June, I'll be giving you time. Again, I'll be assigning you questions, scenario based, proposition based question from part C and D. Then you will be sending these answers to me. I'll be checking them and giving you feedback. Then 23rd June. So based upon all these answers, based upon everything, so I will be then holding a detailed answer writing session. So based on your practice answers, final tips, tricks, everything. Also in this lecture, we will be doing final revision of our whole syllabus. So what are the course details? So in this course, you will be getting video lectures newly recorded as per schedule, then detailed notes, theory, practice questions, then solved latest sample paper. All answers IRAC format, answer writing practice, personal one-on-one checking of answer with feedback and guidance. So price for complete course is Canadian dollar 150, INR 9,000. If you want to purchase only notes, then with practice question, then price is $85 Canadian dollar, and only video lecture without notes and practice question $100. So rest, if you have any other query, you are more than welcome to send me an email on demystifycanadianlaw@gmail.com, or you can DM me on my Instagram page. Then one more thing. So after every lecture, you will be getting the lecture PDF. So this is how my lecture presentations will be going to be. So why I make these kind of presentation form lectures? Because one thing, you won't find the subject boring. It won't look like exactly I'm reading from the notes. Secondly, you can use all these lecture PDFs for your revision. So this will be very helpful for you. So this is going to be the first lecture that I'm going to take up today. So in this form, you will be getting lecture PDF after every lecture. Then I can show you So in this lecture, we are going to cover two important first topics. So the number one is the legal profession, lawyers in society and society of lawyers. Being a part of legal field, one should understand what does word profession means under law. So this is the first topic. Next, lawyers in society. So we are a part of society. Being lawyers, we represent an important field. So how society expects us to be, what kind of relation you have to make with your clients. So whether your client accept loyalty, whether they accept some kind of trust. So all these things, what kind of society together we make in this legal field as a lawyer. So these things we are going to study in this first topic. So the issues to consider under this topic: what is profession, what is public interest, how people see you, so what they expect, role of lawyer and profession, legal process and society, law as a business, whether one should see law as a profit making thing or we have to serve society with this profession. So law as a profession, what is the difference? Are these two things conflicting? Must it be one or the other question? What is at stake in this discussion? Power, opportunity, responsibility of lawyers in society. Can lawyer dominate anyone? So what are the opportunities that you get being a lawyer? Like you get so much respect. This is the biggest opportunity I feel. Then what is the responsibility? What you have to give back to the society as a lawyer, what you have to give back to your clients? Legal ethics. So what all moral principles you have to take with yourself while you are into this profession? So you have to imbibe few things within yourself under your moral compass. So what are all those legal ethics? What is the orientation of lawyer's value framework? What role do values principle play in determining the obligation of lawyer? Loyalty, integrity, justice, these moral principles, these ethical codes, what does these mean? Where does these things stand? So lawyers obligation to themselves, they should be truthful, then to client, to court, to society. Is there any conflict between these duties of lawyer? So we will be studying that. Then lawyers are seen as moral or morally neutral actors. How much this statement is correct? Should personal honor, personal morality, extra play a role in lawyering process? What are the various arguments on either side of this question? What model code provision animate both sides? Is there a conflict? How should it be resolved? Whose morals are we talking about? So here when we are talking about ethics, morals, whose morals? Lawyers, clients, societies, or anybody else? So all these questions will be answered one by one under this lecture. So once we are familiar with profession, what is a legal profession? Is this a profit making? Is this a service? Then how a lawyer should be in the society, ethics, morals of a lawyer. Then we'll talk about how this lawyer thing, this legal profession is regulated. So is there any law society? Who controls? So the roles and responsibilities of law society in governance of legal profession, this we will be studying. What are their purpose? Are the purposes being achieved? What alternatives might be considered? How legal profession is structured? What kind of education you need? Is this a self-regulated profession? Then what are the statutory ethical regimes? Good character requirement to practice law, one of the most important qualification after education. So first is education, that is must. You must have a law degree and all other important qualifications. Second is a person who has to practice law must be a person of good character. This is in itself a very important essentiality. Accountability. Can someone question you if you are not truthful to your client? What would be the consequences? So we will be studying that. Competence, how much quality of service one expects from a lawyer. Candor, admission, conduct, discipline. Unauthorized practice, what a lawyer can do, what a lawyer cannot do. Language rights, So whether a lawyer has to respect the language requirement of his client. Equity, diversity, inclusion. Whether a lawyer can discriminate on any grounds with anyone in regard to client representation. So we will be studying all these questions today. So I hope now you have gotten an idea about the syllabus. So this is basically the syllabus as it is the language. I am focusing on each single word so that you can get an idea about what we are going to study. The only thing that you need to have within yourself in order to pass this examination is your dedication to understand the concepts by heart. By heart means as and when, along with me, when I will be discussing the topics, just try to imagine this. Just feel that you are already a lawyer. So what you will do in this situation? Is this situation morally, ethically right for you? Is this what you feel? Whether particular conduct is uh, could be considered as a professional misconduct, then is profit making should be the purpose or there should be a balance. So just relate things with yourself, then you will find this subject super easy. So now first thing, professions and professionalism. The profession of law and law as a profession. What does word profession means? So firstly, the word profession has two things. One, we use this word for a particular person. A professional person is the one who has some expertise in some particular field. Like we use medical profession, doctor, then we use law profession, so lawyer. So it means you have particular kind of expertise in that field. We never use business term for a doctor's profession. So this is the first difference. Second thing, whenever we talk about profession, be it teaching profession, be it lawyering, be it medical profession, ethical principles govern it. So side by side, your legal requirements demands you to perform ethically right. So morally right, what society expects from you. So professional by definition embodies dual commitment, one to their field of expertise, one you have to perform as per your field. Second, you have to perform as per ethical principles that govern your profession. So every profession has some ethics attached to it. What are ethics? So ethics as such are not any laws. They are the things that a person as per his or her own personal moral compass feels right or wrong. So what a person beyond law, beyond any written rules, feels that based upon your inner conscience, your inner calling, that whether a particular thing is right or wrong. So ethics are your inner calling. So as such, this inner calling word is not some defined term. When I was doing my post bachelorate, so we had a subject on ethics, and there in one of our class discussion a student used this word. So our teacher found this word really interesting. Even now when I am teaching, I think this is the best word to explain someone in simpler terms what is ethics. So it is your inner calling, what you think in a particular situation is right or wrong. At its core, professionalism encompasses a blend of education. So what else? So a profession has education, some kind of moral integrity, dedication to service. So these are all things that makes something a profession. So you have a degree, you have few moral integrity, you have few extra dedications for that service. Firstly, a profession is typically a member of recognized professional body, as I told you earlier, medical, education, lawyer, any kind of body. A distinction earned through attainment of specific educational qualification. So in order to be recognized as a professional, you should have some essential educational requirements, qualifications that are required to be done for that particular profession, for that particular field. However, this membership entails more than just academic credential. It signifies a pledge to adhere to a prescribed moral professional code of conduct which serves as the bedrock of their practice. So you might have heard about medical profession ethics, then teaching profession ethics. So usually there is a kind of a book ethics code which all the professionals have to follow. So it says that if in case there arises a situation where you think that you have to make a decision out of your professional educational qualification, your educational guidelines, then what helps you in taking that decision? So that is your moral ethical code of conduct. So here if we talk about lawyering thing, then again there comes many situations. I would say again many situations where you have to take a decision as a simple human being out of the role of a lawyer. You have to make a decision whether you want to take up a case of a particular client or not. So sometimes we might have seen this thing in rape cases a lot. So in India especially, we have seen so many times that there comes a situation where someone has accepted or it's evident that this person has done something heinously wrong. So kind of very barbaric, heinous crime. So usually what happens, few lawyers, they just say that we don't feel this is morally right, so we won't be representing this person. So the accused person. So these kind of situations come and you can take a decision based on your ethics. Similarly, if we talk about doctors' profession, when a patient is on ventilator, there the doctor who don't even want to take someone's life sometimes have to make a very tough decision. Even in case of euthanasia, so euthanasia also like this kind of situation, the moral concept is much debatable these days, whether it's morally right to take someone's life or not. So this moral rights revolve around the doctor's role, questions doctor's profession. So it happens in every profession again what we say that your education plus your moral integrity both go hand in hand. So this is the basic idea about a profession. So next is what is professionalism? Professionalism is your attitude, what you think about a particular conduct. So that is professionalism. Sometimes we usually call this term that okay, this person is not acting professionally if someone is rude to their client, if a doctor is not taking his patients effectively, patiently, or a lawyer unnecessarily just because he's getting some other good client who's ready to pay more money and things like that. So we usually use this term that okay, this person is not acting professionally. So that is not professionalism. This is not how you approach. Sometimes even in educational field also, even in our previous colleges, in once in a while we might have seen some professor, teacher, or even some student for that matter disrespecting their professor. So we usually use this term in a day-to-day life as well that okay, this is not a professional behavior. So what is a professional behavior? So a professional behavior is that attitude that justifies your conduct. If you're doing something and that don't justify your conduct, it means you are making an unprofessional behavior. So an approach or attitude that embodies a justification for a particular course of conduct within a wider account of a morally defensible modus vivendi, mode of living, agree to disagree. It has a vital moral dimension that defines who lawyers are, what they aspire to be individually and collectively. So this definition has been given by Alan Hutchinson. So this important name you have to mention in exam as it is. So as per Alan Hutchinson, any approach, any attitude, any way of conduct that justifies that whether you agree to something or disagree to something has some moral justification behind it. That is a professionalism. What are the elements? What all things comes under professionalism? What all things together make professionalism? So your competence, where you stand, scholarship, integrity, honor, your leadership, independence, pride, spirit, enthusiasm, how strongly, how effectively, how impactively you are making your statement. It's not that always if you are disagreeing to someone, someone will say, okay, you are having an unprofessional behavior. No, it all depends upon how rational point you are making. Collegiality, civility, service to the public good, balanced commercialism. Next important topic is what is public interest? So public interest means what society seeks, what society expects. So from a lawyer, what do you think society expects? So very simply, not from only lawyer, but from the whole legal system, society expect the public interest is always in justice. So are we Sussex justices ex parte McCarthy? So in this case, it has been held that not only must justice be done, but it must also be seen to be done. People should see that okay, effectively justice has been done. So this principle of public interest underscores what it demands. It demands that importance of not only ensuring the fairness, impartiality, but also people should have a trust in our legal system, in our justice system. It's not just that you just show people that okay, I have done something fairly, I have given a decision impartially. No, people should have trust, a strong trust in our justice system. So upholding the welfare of society is another important principle under public interest. So public interest is the welfare or well-being of the general public, society at large. So it basically depends upon how whole realm of law and governance work. It serves as a guiding principle, the public interest, for policymaker, lawmaker, legal practitioners alike directing their action toward the greater good of society. So what does public interest demand? Justice. What for what we do justice? We do justice for the greater good of society. So this is how you have to relate the concept so that things can get into your mind as a storyline. Imperative importance of public confidence in justice. So this thing has been emphasized, the public interest concept has been emphasized in the case of R versus Neil. So in this case, it was emphasized that public interest is the most important integral part of administration of justice. So if you want people public to have confidence in the legal system, then fairness, transparency, effectiveness, these three things are must. Now what is the role of lawyers and the profession in legal process in society? So firstly, a lawyer and client both have fiduciary relationship of trust. Fiduciary means trust. If someone is coming to you tomorrow with their case, with their issue, then what do you think the person is coming with? So the person is coming with hope, trust that you are going to save that person from the trouble in future. So fiduciary relationship is the basic ground norm on which this whole lawyer and client thing stays. So in legal profession, all lawyers are bound by fiduciary relationship with their client, which is built upon what I told you: trust, loyalty, hope, confidence. So this aspects underscore the lawyer's obligation to act in the best interest of their client and to prioritize their needs above anything else. So ethics is the cornerstone of legal practice. Ethics occupies an important central position, as I told you earlier. From the beginning only, you must be thinking that I have been again and again talking about morals, ethics, because these are the guiding principles for a lawyer. So the whole professional conduct, decision making revolves around ethic. So upholding ethical standard ensure integrity of legal proceeding. It shows that a lawyer is fully dedicated towards its client, that a lawyer is working towards the ensurement of integrity in legal proceeding, and this ultimately maintain public trust. And this ultimately brings the concept of public interest. Next is self-regulation in Canadian legal profession. So when we talk about Canadian legal profession, it is a self-regulated profession. Lawyers are primarily responsible for regulating their own conduct. Basically, this autonomy is there in order to safeguard the independence of legal profession from the government influence or their domination. So what is the role of lawyer in society? So first thing, lawyers play a very important role in upholding justice because they are the main players, main actors who bring justice from court to a person's home. So this is a important concept. Lawyers play a crucial role in the preservation and regulation of society, ensuring the functioning of legal framework, upholding justice. As noted by legal scholars Joseph Raz and John Rawls, these two legal scholars have given their viewpoint on lawyers' role. What do they say? So they say law serves as cornerstone of social order, providing framework for governance and defining the basic structure within all activities that take place. So if you want public peace, if you want peace order in society, then whose role is it? So it is the law's role. So it's the law that maintain this public order. If a system, if a country, a nation has strong legal justice system, then obviously their people will be living at peace. There will be a good social order. Public will have trust in system. There will be impartiality, there will be transparency, the effectiveness, which are the three important principles under public interest. So all these things relate to each other. So these are the viewpoints of these two important scholars. Law as a business, law as a profession, what do you think? So one should understand the difference. So when we read the word business, so the first thing that you should understand is wherever you read word business, the word profit comes into picture. So when viewed through the lens of business, the law firms operate similarly to any other commercial entity offering services to clients in exchange of compensation. So when we talk about law business, so in which form you see legal business? So legal business in our society is in the form of law firms. So corporations, law firms. Business transactions are a common occurrence within law firm reflecting the economic realities of legal marketplace. So when now we have legal firms, this somehow reflects that our legal system has entered into a business marketplace. So acknowledging human dignity in legal practice. However, one should recognize that the practice of law transcends from commercial transactions. So what does this mean? This means that okay, it's important that few people are doing their business. So they are absolutely free to do that. No one is stopping them. But what should be the balanced approach? So balanced approach should be to acknowledge human dignity side by side. So it means that law firms, when they are charging good amount of money, when individuals are seeking legal assistance, they should maintain their dignity, humanity. So such reductionism means this profession to business thing. Profession as a lawyer to law firm a business thing should not just keep things monetary. It should overlook the human cost of legal issue and profound effect they have on individual lives. So law firms should maintain a balance between dignity and the cost they are charging from people. So law as a profession, it's an elite form of livelihood. Many people think that lawyers are the people who earn the most. So law as a profession is often regarded as independent self-regulating entity distinguished by its elevated status, specialized expertise. Unlike conventional businesses, the legal profession enjoys unique dominance. So there is no doubt that legal profession do enjoy unique dominance, but one should keep in our mind that the responsibility is also very, very high on lawyers. So this legal profession is driven by trust, confidence placed in the lawyer to uphold ethical standard and deliver justice. Maintaining integrity of legal profession, this is the main responsibility of a lawyer of this whole profession. So viewing law primarily as a business. So if we see only that, okay, lawyers are the rich people or law firms are making huge money, so this would not be a correct approach. This is diminishing the noble purpose, the sacred trust placed in lawyers to serve the justice and uphold rule of law. So balancing commercial viability with ethical responsibility is important if we want to fulfill our legal profession's important role of providing justice to the society. So the last line reflects, concludes this whole concept of law as a business in the form of law firm and law as a profession in the form of lawyers and what people think that is an elite form of livelihood. So balancing the commercial viability with ethical responsibility is essential in ensuring that the legal profession continues to fulfill its vital. So, as I have discussed this earlier as well, that okay, lawyers are dominant people, people go to lawyers, they have trust in the lawyers. Somehow, in this legal field, they are dominating also, but lawyer's responsibility is to maintain integrity. Lawyer is one such profession where cleverness has no place. You should follow ethical obligation, public trust should be maintained. Only then you can stand in the society. So responsible use of power. People do trust you. You have good power, but judicially, usage of power is of utmost importance. Then we have model code of conduct which guides the ethical principles, ethical conduct of a lawyer. So this code serves as a framework for ethical conduct. It focuses on lawyer's duty as how a lawyer has to uphold, protect the integrity of legal system. You might finding that okay, these things are repetitive. I am again and again talking about that similar thing just in little bit twisted form, but these are the syllabus requirements. You have to go through all these topics by heart, understand the concept, relate it to yourself, because in examination you will be expected to write these things only. So lawyer's duty toward clients is first is duty of loyalty, conflict avoidance, lawyer-client relationship. Most important thing is loyalty, trust, faith. So lawyer should prioritize client's interest above everything else. Lawyer must diligently effectively, smartly, intelligently avoid conflict of interest and maintain a commitment to their client's case. Then, commitment to excellence and public service. So, lawyers are called upon to continually strive for excellence, give their best, no matter what would be the result. That is a secondary thing, but give your best. Harmonizing responsibility as legal representatives. The responsibilities of lawyers and representatives of client, officer of legal system, public citizen are interconnected and complementary. So, as legal representative, lawyers are representing their clients. Number two, they are the officers of court. Number three, they are public citizen. So, all these three roles go side by side. Next is what is legal ethic? Basically, again, legal ethics are all those commitments that guide, that tells, informs a lawyer how to practice law. So, what should be a professional behavior? What are the boundaries? What are the expectations from a lawyer? So, these are legal ethics. Ethical commitment that guide the conduct of practicing lawyer, delineating both boundaries, aspirations of their professional behavior. Ethical principles encompass a spectrum of rule, principle, legal obligation, as well as moral and ethical aspirations, shaping the ethical landscape, how a lawyer should operate. So these are the guiding principles for legal professionals. So these are the compass, as in the beginning also I used the word moral compass. So moral compass is your own personal set moral ethics. What you feel. Like my top personal moral compass thing are honesty, integrity, and trust. So every person has their own individual preferences when it comes to their moral compass. So same for a lawyer, we expect few basic common moral compass things that should be there, like loyalty, as I told you, integrity, candor. So these are the things that one should expect from a lawyer. So these are the guiding principle that goes with the main standard set law. So value of integrity, honesty, justice, and how they interact with clients, their colleagues in legal system. So all these things are under the guiding principles of legal practitioner. Then legal ethics play a crucial role in fostering right and proper conduct in daily practice of law. Where does integrity stand? So what does the word integrity in simple English language means? So integrity means quality of being honest or having some set moral standard. So while not explicitly defined anywhere in model code, integrity is implicitly woven in its fabric. Commentary accompanying the model code suggests integrity encompasses quality. What does integrity as per the model code of conduct's commentary suggest? So it suggests that integrity means qualities like trustworthiness, honorability, responsibility. So lawyers are expected to conduct themselves with integrity, avoid any conduct that can doubt, that can question their character. So a lawyer should do his or her job in that effective manner that tomorrow no one can doubt that okay, this person has not given his or her best to client. So may cast doubt on their character, undermine the trust placed in them by client and society. By upholding the principle of integrity, lawyer contribute to the maintenance of ethical standard, preservation of profession's reputation. So this is the moral code 2.1 to 1 rule. A lawyer has a duty to carry on practice of law honorably and with integrity, as it is you will have to mention in the exam. Then commentary particularly expands the concept of integrity. So what does commentary says? Integrity is a fundamental quality of any person. Any person who wants to practice as a member of legal profession, integrity is very important. Now in exam, if you are getting a question on integrity under analysis, this is how you are going to start. That okay, As per section 2.1, commentary integrity means this. Now, as per the facts of the case, this person has lacked here. So this person has lagged here, or this person has followed integrity point. So we cannot question the integrity thing here. So this is how you have to relate things in your exam. So if a client has any doubt about the lawyer's trustworthiness, essential element in the true lawyer-client relationship will be missing. If integrity is lacking, lawyer's usefulness to client and reputation within the legal profession will be destroyed regardless of how competent the lawyer may be. So no matter what degrees you have, if you are not honest to your client, all degrees are in vain. Lawyers' obligation to themselves. So conflict often arise in the realm of legal practice. Be it anything, conflict is always unavoidable. Be it in your personal life, professional life, we all know that conflict comes and goes. So stemming from the inherent tension between lawyers' obligation to their clients, the court, the society at large. This multifaceted duty creates a delicate balancing act that challenges lawyer to navigate complex ethical dilemma. So conflict commonly arises due to simultaneous duties lawyers owe to their client, court, society. Striking a balance these obligations is not easy feat as each carry own set of expectation demands. So conflict arise, but what should a lawyer do? So in this case, whenever a lawyer feels pressurized, conflicted, sustainable professionalism has to be the approach. Sustainable professionalism means lawyer has to, in order to face a conflict situation, a lawyer has to reconcile lawyer's principles, interests, personal life experiences with broader societal concern. Means here a lawyer cannot just think about himself or herself that okay, I think this is wrong, then this is wrong. No, what society expect, what court expect, what are the client interest expect. So lawyer has to make a decision according to that. So this is what a true sustainable legal professionalist imbibes in itself. So concept of sustainable professionalism comes into picture whenever we study about conflict. So addressing this complexity is the notion of sustainable professionalism. So whenever conflict arises, where will we go? We will be going to sustainable professionalism concept, which seeks to reconcile. Reconcile means to make everything okay. Lloyd's principal, interest, life preference with broader societal concern. This discourse acknowledged the importance of balancing the interest of client with aspiration goal like equality, access to justice, protection of public interest. By embracing this approach, lawyers can navigate conflict more effectively while upholding the values of their profession. So who provided this concept? So Trevor Farrow. This is important name in exam. You have to mention, refer this name. Acknowledging conflicts between professional and personal morality. Elise Woolley highlighted this thing that inevitably, as I told you earlier, unavoidably, the conflicts do arise between professional and personal morality in legal practice. Sometimes you have a case that is morally wrong to take up, but professionally it is right. So these kind of conflicts do come and go. You cannot always avoid. You cannot always make one decision. Sometimes lawyers should strive to minimize circumstances where such conflicts are likely to occur. So how a lawyer can do that? By exercising vigilance, ethical discernment. Lawyers can uphold the integrity of their profession while remaining true to their personal values. So lawyers as morally neutral actors. What does these term means? Morally neutral actor. So this means that it's not always that one person feels that a particular situation requires moral quality or moral intention, but situation is such that you have to take decision, you have to make important announcements based upon ethical considerations. So morally neutral actor is the one, that individual who does not inherently possess any moral qualities or intention, but such as an actor do by actions, by decisions. There shows some kind of morally guided reactions. So morally guided results. So this is what a lawyer usually does. So principle of neutrality, lawyers must maintain impartiality regarding the moral merits of their client's case or objective. Every individual harbors their own opinion, perspective, bias deeply ingrained in their subconscious. Consequently, achieving complete moral neutrality, separating law from morality in practice, possess a considerable challenge for lawyers, because every person has their own biases, own perspective, own opinions. It's not always that whatever your client is expecting, a lawyer feels the same. But ethical responsibilities of lawyers have always been a subject of debate, especially when it comes to loyalty to clients. So, what level of loyalty demands this profession? So, the lawyer profession demands complete loyalty and justice. So this tension is well illustrated by the contrasting views of loyalty and justice within the legal profession, ethical implications discussed by theorists as William Simon and David Lubin. So they have told that, okay, this is a never-ending concept, this is a never-ending debate. We cannot always say that, okay, a lawyer has to 100% follow the client's moral principles or moral expectations, but in reality, what happens? A lawyer has to be 100% truthful to few basic moral expectations, that are loyalty, honesty, justice, then candor. Justice versus loyalty in legal ethics. So, the Federation of Law Society of Canada's Model Code emphasizes justice more frequently than loyalty. So, justice word has been used more than loyalty words. So, now what does this mean? So, this simply suggests us that the Canadian Law Society, the ethical practice, prioritize justice more than loyalty. So, it says that the final thing that we are concerned about based upon a lawyer's action is that a person, a client should get justice. So we are not talking only about loyalty. Loyalty could be a part of justice, but ultimately we have to look whether a particular client has got justice or not. So there are many critiques of loyal advocacy who says that a lawyer cannot always show, like as I discussed earlier, that a lawyer cannot always give unwavering commitment to advance a client's cause. So this has created a lot of criticism. So some says that, okay, this approach can absolve lawyer of moral accountability for the client's objective. Instead, there is a call for lawyer to retain their moral agency, exercise independent judgment, ensuring that the client's proposed action aligns with justice. So this shift in perspective challenges the traditional notion that a lawyer's duty is solely to client, irrespective of broader ethical consideration. So this is the criticism. So many theorists, many legal scholars, as we discussed earlier in previous slide also, says that how much commitment, how much loyalty should a lawyer give? 100% commitment. So again here they are saying that ultimate goal is alignment of justice. Lawyers' actions, lawyer work should provide justice to their client. It does not mean that a lawyer should surrender himself or herself to his client. So this is the difference. This is how we say that neutral. Next, the case R versus Murray 2000. So basically, this case highlights the ethical dilemma, the moral conflicts that a lawyer faces in practice. So Murray, the lawyer for Paul Bernardo, was charged with obstruction of justice for withholding incriminating tapes. The court's decision hinged on ethical conflict between duty of candor and confidentiality. Tapes which predated solicitor-client relationship and constituted physical evidence were not covered by privilege. The court ruled that while maintaining confidentiality, a lawyer must turn over any incriminating physical evidence. So, although the court says it okay, the lawyer, in order to save his or her client, has to maintain confidentiality, but that does not mean a lawyer should incriminate or should falsely hide any physical evidence that comes into lawyer's possession. But there is no positive duty to assist the crown in this case, but this is the important thing that court has come up with. So this case underscores the complex interplay that a lawyer's duty to their client, whether they should incriminate in order to save their client the evidence, or their broader, wider ethical obligation towards the court. So these kind of ethical situations, ethical dilemmas do come and go. Again, I am saying all what is required, necessity for lawyer to navigate these challenges carefully, ensuring that his professional responsibilities, his actions should go hand in hand in order to ultimately provide justice. Embracing values of autonomy, equality, diversity. So this is important article by Stephen L. Pepper. So Luban and others argue that an ethical lawyer cannot unequivocally prioritize zealous advocacy or moral detachment. So what does zealous advocacy mean? So although we will be talking about this zealous representation further, but here you should understand that zealous means when without thinking anything else, without thinking any repercussions or what court expects, a lawyer is just thinking about how by hook and crook a lawyer can just win his client's case. So this is called zealous advocacy. So many people, many scholars do argue that okay, that a lawyer cannot do that. Some says that it's okay, it's lawyer's independent judgment, it's lawyer's own priority, they can do that. So what does Trevor C. W. Farrow identifies? So he So again here, like we discussed earlier, the concept of sustainable development comes into picture. So he says, Pharaoh, two primary perspective, those who believe lawyers can or should be guided by personal or communal morality in their work for client, and those who do not. So what Trevor Pharaoh has to say, again, that the right approach should be a sustainable professionalism, that means a balance, neither zealous representation nor that you are only doing what you feel is right. You are completely ignoring your client's perspective and expectation. So we are again and again talking about ethical values that a lawyer has to follow this, lawyer has to follow that. From where these guiding principles come? So firstly, any precedent, any case law, legislation. Secondly, the code that we have, model code. Thirdly, decision from legal regulatory bodies conduct. Fourthly, ethical principle or standard of practice. So these are the four important sources that guide how a lawyer should perform ethically, morally. So, philosophical perspective on ethics and morality. Ethics or moral philosophy entail organizing, justifying, advocating for concepts of right and wrong. As I told you earlier, what is right, what is wrong, what you feel. So, this is ethics. So basically, ethics govern, regulate a human behavior, what you personally feel in a particular situation is right or wrong. So how you approach a particular situation, your inner calling again. So what are virtue ethics? So virtue ethics are basically the moral character of the individual rather than their action. So this is what your character says. So virtue ethics does not mean that what your consequences, what your results of actions are saying. Virtue means what you as an individual reflects. So, as a lawyer, what are the virtue ethics? So, your character development as a lawyer. like your integrity, your trustworthiness, your commitment to maintain justice, then how you maintain client relationships. So building and maintaining honest and respectful relationship with client. So this involve not only advocating zealously, so as I told you in last slide, but also ensuring that the client's best interests are pursued ethically. You are not doing anything wrong against law, illegal in order to save your client. So your courage to make tough ethical decisions, even when they may be unpopular or come with your personal or professional risk. Next is empathy, compassion, community, contributing to legal community as a junior lawyer, as a pro bono worker. So all these things comes under virtue ethics. These reflects your character as a lawyer, as a person. Then continuously time to time self-reflection, regularly reflecting on one's own practices, decisions to ensure that they align with virtuous conduct, the right conduct, the good conduct, and making adjustments as and when necessary. So, by focusing on virtue ethics, a lawyer can basically enhance their moral and ethical decision making, which can lead to a more just and equitable legal system. So, this is the role. I hope this whole concept will get clear with this explanation. There are few other important concepts that we study under ethical lawyering. So, utilitarianism, it means doing something that maximizes the happiness of all. So, John Stuart Mill, Jeremy Bentham, these are the main proponents of utilitarianism. So, this concept says that do something with which you can bring maximum happiness of maximum people. So, majority of the people in the society should feel happy. So, ethical theory of consequentialist utilitarianism, which we call. So, your consequences, action, result of a lawyer should be such that it brings maximum happiness in the society. Postmodernism. So, postmodernism means that okay, morals, ethics are important, but one should also take side by side reality, truth, rationality into picture. So this concept focuses on ethical lawyering with a rational approach. Deontological theories of right action means that morality is determined by whether an action in itself is a right or wrong. So rather than just waiting for the action to get implemented, then you see the consequence, the result, like we see in utilitarianism, whether the result is bringing maximum happiness or not, one should see that whether one's actions at the very first stage are right or wrong. Then pluralism. Pluralism says that okay, there is no one single correct logic. So every person has their different views, different values, different approaches towards a particular situation. So one should be open to plural approaches. So these are the basic philosophical things that guides ethical lawyering. Now, for examination point of view, whenever you will be getting a scenario based question on ethical lawyering, three things that you will have to check one by one relating to the facts, that okay, in this particular case of A versus B, whether if the person A is in question, whether A has performed loyal advocacy. Number two, whether A acted as a moral agent. Number three, whether A has performed integrity well, whether A has performed the integrity, honesty, candor well, whether A has infringed any client lawyer relationship. So, all these three things will be analyzed under ethical lawyering. So, what is loyal advocacy? Loyal advocacy means that you are adhering to ethical principles while advocating zealously for your client. It's okay, it's good that you are trying your best, you are giving your best to win case for your client, but you have to perform a loyal advocacy. Loyalty towards your profession, towards court, towards everything is of utmost importance. Again, it main thing that it imbibes is that it requires is loyal advocacy, that a lawyer should not take his or her client for granted. For his client who has chosen a person for legal representative, you should give your 100% diligently, competently, within bounds of law. Nothing illegal. You don't have to do anything illegal, within the boundary of law. Perform your duty, your advocacy with 100% loyalty. Give your best. So this is the concept of loyal advocacy. Then lawyer as moral agent. So lawyers not only act as legal representative but also as moral agent, as we have been studying from the very beginning of this lecture. So lawyers' duty is also to uphold justice, bring transparency and fairness in their action. Thirdly, integrity. So integrity is the cornerstone main thing under ethical lawyering, because integrity in itself imbibes so many other ethical moral concepts like honesty, transparency, then trust, confidence, so all these things. Canadian lawyers are obligated to practice law and discharge responsibilities honorably with integrity as outlined in Rule 2.1. This we read earlier as well. Then we also talked about the commentary which expanded the concept of integrity, so you can even refer to that as well. So conduct that reflects adversely on a lawyer's integrity, whether in private life, professional life, may warrant disciplinary action. So if a lawyer is not performing with integrity, then a disciplinary action could be taken against that lawyer. So first case, R versus Neil, although we gave reference a little bit earlier to this case, but here we'll be talking about three important cases in detail. So this case shows that fiduciary relationship, fiduciary means relationship of trust between a lawyer and client, means duty of loyalty. So the first principle of ethical lawyering, loyal advocacy. So in this case, the appellant sought a stay of proceeding in criminal trial due to conflict of interest stemming from law firm representing both him and co-accused. So there was a law firm that was representing the appellant as well as the co-accused. So appellant sought stay of proceeding. Brogham's maxim underscored the primacy of loyalty to client, affirming it as a paramount duty of an advocate. So loyalty is crucial for maintaining public trust in the integrity of justice administration. So the judge emphasized that lawyer-client relationship hinges on client's trust in counsel's loyalty. So if a lawyer is representing both parties, that does not show the duty of loyalty. So that questions the fiduciary relationship. So fiduciary duty entail avoiding conflict of interest. So whenever there is such conflict of interest, that has to be avoided by a lawyer. So this is the basic requirement of ethical lawyering. Next is the Strother case. So in this case, it was held that fiduciary duties imposed on lawyers beyond contractual obligation. So it isn't always that whatever there is an agreement between a lawyer and a client, only that has to be followed by a lawyer. No, there are few other things that are unwritten but are important for a lawyer to follow. So which includes loyalty, conflict avoidance. So lawyer's retainer agreement, while contractually defined, is subject to fiduciary responsibilities which may extend to matters not expressly addressed in the retainer. So duty of loyalty includes providing candid advice on all relevant matter, even beyond the scope of retainer. So even if there is something that is just beyond the agreement, the retainer agreement of a lawyer and client, duty of loyalty, it says that okay, it's fine, a lawyer can give advice to his client even beyond the agreement. Then we have Shesford versus Shawdor's case, 1986. So Mr. Shesford's lawyer engaged in an affair with his wife. A lawyer is prohibited from using confidential information for personal gain or to the client's detriment. So here lawyer engaged with an affair with his wife. So client's wife. The highest form of fiduciary duty requires advancing the client's interest exclusively without allowing any personal interest. So no personal interest should come into picture when you are handling any client's case. Breaching this duty undermines the trust in solicitor-client relationship. So reasoning, using confidential client information for personal gain violates fiduciary relationship, eroding trust in solicitor-client relationship. So this is obvious, very obvious from the facts itself, that if a lawyer is doing something like getting in a relationship with client's wife and then gaining some personal advances from that, that definitely 100% undermines the lawyer client relationship. So now moving with our next topic, regulation of lawyer and regulation of law profession. Who regulates law profession? So in Canada, this profession is self-regulated, means the law societies, they primarily govern. So these societies are authorized. The power has been given by provincial and territorial legislatures, laws to oversee the legal profession in public interest. So these societies, these get their power, their authority from legislatures, few laws. So self-regulation means that a profession that is regulated by its own member. So if we are having lawyer profession as a self-regulated profession, it means that only law societies make rules and regulations. For lawyers, this means their professional conduct is controlled by rules created by their peers within the law society. So self-regulation means there is no outside interference, no government, no administrative interference, no ministerial interference. So this you have to keep in mind. So autonomous governing body, the law societies every province has. Specialized knowledge, lawyers must undergo extensive formal education, then practical training. Then admission is restricted in self-regulated professions. What does this mean? This means that only individuals who have competent qualifications are permitted to admit into this. So when we talk about this legal profession, that there is no outside interference, it is self-regulated, it is independent. So it means protection of individual rights and liberties there. So independence is important so that people's right, individual rights, freedom should be protected without any interference. Without any interference of whom? Government, state, bureaucrats. So justice should be delivered in its truest sense, and that can only be done if a particular legal profession is independent. Legal profession has historically developed independently of government control. That is why we are continuing doing that. So judiciary has always been an autonomic body. There is an important case of Canada Attorney General versus Law Society British Columbia. The Supreme Court of Canada affirmed the necessity of legal profession regulating itself independently to ensure the delivery of unbiased. So Supreme Court of Canada says that if we want to deliver unbiased legal services, particularly in areas like public and criminal law, then it is important that this profession should be self-regulated. So independence of bar from state is an all-pervasive manifestation, one of the hallmark of free society. Regulation of these members of law profession by state must, so far by human ingenuity can be so designed, be free from state interference in political sense. So in what sense we are saying free? Only in political sense. Federal of Law Societies of Canada has introduced rules to combat money laundering, including prohibited lawyers from accepting large amount of cash from clients or third parties, implementing new record keeping requirements regarding cash transactions. So this means that there are checks. So if government is not checking, who is checking? The law society. So law society in itself is such a great and excellent working authority body which is time and again making changes in its own rule so that the legal sanctity, the pureness, the independence of this profession can never be questioned by anyone outside. So, in order that the lawyers should perform their duties ethically, morally well, now anti-money laundering regulations has also been introduced by FLSC. Now, arguments for self-regulation. Some says that lawyers possess necessary education experience to understand the complexity involved in regulating legal profession, their expertise in their field, so they don't need any other oversee. They can oversee their own conduct. Also, self-regulation is more efficient, cost-effective with administrative and enforcement costs covered by the members of legal profession rather than by any taxpayer. So structure, as we already studied, the law societies and self-regulation of lawyers in Canada. There are provincial and territorial law societies. Self-regulation of law profession Canada, primarily managed by these societies only. So law societies have broad regulatory powers. So as I discussed earlier as well, the kind of FLSC regulatory has included recently inserted the money laundering regulations. So these shows that law societies have broad regulatory powers. This framework ensures that delegation of authority exercise aligned with legal standard principle, including those enshrined in the charter. National Corporation and FLSC. So FLSC is a national level self-regulating body in Canada for legal profession. So over past 2 decades, this has been performing excellently through cooperative efforts among law societies, and law societies are coordinated by a main body, the national body, that is Federation of Law Societies of Canada. So this is the national body that facilitate checks cooperation consistency across all other provincial and territorial jurisdiction. So then we have National Mobility Protocol. One significant initiative step that FLSC took is that they make a rule, a protocol. So basically, there are common protocols that are driven by the need for more consistent, efficient regulation of lawyer movement across provincial boundary. So some says that these legislations have diminished the self-regulation. So autonomy of law societies have been somewhat reduced by increasing use of legislation to regulate certain aspect of legal practice. So legislative measures like anti-money laundering regulations and other areas where uniform standards are necessary so are important to introduce. From where the self-regulation source opportunity responsibility comes from. So entry regulation concerns the admission of qualified person to profession. So in order to enter into this self-regulation, there are few admission qualification requirements like the degree and all. While conduct regulation involves the following of practice standard norm, the code of conduct and all that. So apart from these two things, the entry regulation and the conduct regulation, contemporary modern self-regulation entails the regulation of lawyers' account through detailed rules, enforcement practices like audit, then operation of insurance, assurance fund scheme to compensate client. All these things keep a check on this self-regulation. So in addition to the internal regulation governing lawyer conduct, several external bodies and mechanisms play a crucial role in regulating the behavior of lawyers in Canada. So these external bodies help ensure that lawyers adhere to ethical standards. So what are these bodies? Number one, the courts. So the courts play an important role in regulating lawyers' conduct through their decision on malpractice, professional liability. So also like we will be getting examination scenario based question in which we'll be seeing whether in a particular case a lawyer has done professional misconduct or not. So in those kind of analysis, what we are going to follow? We are going to make our analysis strong by following legal precedents, the decisions that court of laws has already given. So what are these? So these are the things that keeps a check, except the self-regulation. These are the bodies that keeps a check on the lawyer's behavior. So indemnity insurance schemes are there. So lawyers in Canada are required to participate in indemnity insurance schemes operated by provincial law society. So these schemes, what do? They compensate, pay back the client for losses that a lawyer's negligent misconduct cause, providing a financial safety net and promoting accountability. Then we have voluntary membership, like Canadian Bar Association. This is a national organization. Then we have specialized lawyer groups, then harmonization and national standard. So in Canada, there is a trend moving towards a national standard for provincial law societies. So they says that there should be a proper set common rules and regulation across provinces that facilitate lawyers' mobility and strengthen the bar's national political position. So this approach supports broad discussion on ethical standard and how we can maintain a consistent, a continuous ethical framework in the whole nation. Now, what kind of education is required if you want to enter into legal profession? So to practice law in a provincial territorial jurisdiction Canada, individuals must be admitted to law society of their jurisdiction in whatever province they are residing. This admission process involves fulfilling pre-admission requirement plus good character. So there are two important qualifications: education and good character. So good character in itself is considered as a proper qualification. So in academic education, you must have a degree, then practical training, as we know, articling, bar exam, then professional then every province has their own rules regarding to articling and all. So that differs from province to province. Talking about good character. So in addition to meeting educational practical training requirement, applicants for admission to legal profession Canada must establish, this is mandatory requirement, that they are of good character or possess good character and reputation. So this requirement is intended to ensure that not only individuals with moral integrity and trustworthiness are admitted to practice of law. So persons with good moral integrity whom you can trust, whom a person can trust to represent in law, in court. So those kind of persons should come and become part of legal profession. So purpose and enforcement of good character requirement. Number one, so person individual who is entering into legal profession must deserve that position, is worthy of public trust. Secondly, with the while the intention behind this requirement is commendable, aiming to protect the public, maintain professional integrity, its enforcement has faced criticism for lack of clarity. So challenges in enforcement. So there is no clear definition of what a good character is. So we analyze a good character based on case. So the precedents that cases comes before the court of law, based on that we usually analyze whether a particular conduct is good character or not. So we have few such cases related to good character, in which the number one case, that is one of the most important landmark case, is Pereira versus Law Society of Upper Canada 2000. So in this case, what happened? From 1994 to 1998, an applicant falsified his credential in order to secure articling position. So in 2000, that applicant applied for admission to Ontario Bar. Hearing aimed to determine if the applicant was of good conduct given his past action, whether he had reformed his character by the time of application. So for example, tomorrow if you are applying for articling position, you mentioned some fake experience for 4 years as a legal assistant somewhere. So now this is 100% a bad character thing. So whether the applicant had demonstrated good character in this case. So in this case, the hearing panel has made different determination, observation. So number one, what is a good character? So the definition is evolving, still rising. It is not exclusive. There is no clear-cut definition, but what are the things that we look into when we have to decide whether a particular conduct is of good character or not? Number one, integrity. honesty, truthfulness, candor, empathy, amalgam of all these. So a blend of all these. Proof lies on the applicant to show that good character at the time of application. Standard of proof is balance of probability. Being a lawyer is considered a privilege, not a right. A person should not be given this position lightly. A person has to prove that, okay, I am a person of good character and I deserve to be a lawyer. Transitioning to good character is a process, not a single event. It is not guaranteed that someone with a past lack of good character will become a good character. Outcome, result. So here the applicant failed to prove on balance of probability that he was of good character at the time of his application. So consequently, his application for articling and everything further was rejected. So another case, Law Society of Upper Canada versus Burgess 2006. So there was an issue of plagiarism during her time at the University of Toronto. So applicant lied to Law Society about issue of plagiarism. Question is whether applicant demonstrated good character by this lying to bar for admission. So panel hold that the applicant did not prove on the balance of probability that she was of good character at the time of hearing. So plagiarism, copying someone else's material, 100% shows demonstrate bad character. That is why whenever a tutor, even NCA tutor, even I make notes, make content, video lecture, again and again I urge students to not share further without permission, because this is a bad character. If someone tomorrow says this to bar, then your bar membership can definitely be rejected. So there should be a question, because these things at the very starting. So here, as you can see, even in her university examination, there was an issue of plagiarism, but that thing came up later during her admission to Law Society. So from the very starting, imbibe in yourself these moral characters. Accountability and public interest. So law societies have increasingly emphasized their role in protecting public interest, countering the perception that self-regulation primarily serve law interest. Ambiguity of public interest. So public interest concept is vague. It focused on ensuring lawyers' competence, ethical conduct to provide high quality legal service. Recently, this public interest concept has expanded itself and it has included the concept of access to justice, upholding rule of law, administration of justice, greater efficiency, more transparency, more accountability. So, what's the Canadian Law Society's approach towards this concept of accountability and public interest? So, Canadian law societies have proactively emphasized the need to have public interest intact. So there are complaint investigations, resolution processes, public awareness of complaint process has been increased. So if someone tomorrow feels that okay, their lawyer has not done justice to them or has not performed their duty with full honesty, then the lawyer is accountable because of the public. So, competence, quality, candor, duty to provide competent legal services. Law societies in Canada recognize the duty to provide competent legal services within their code of conduct, ethics, professional conduct. So, you can see definition of competence has been clearly given under Model Code 3.1. So, a competent lawyer is the one who possesses and apply firstly relevant knowledge, skill, attribute in a manner that is appropriate to each matter undertaken on behalf of a client. So, based on the nature and terms of lawyer's engagement. This definition emphasizes that competence is not static. It requires continuous application of skill. As and when you are gaining more experience, you will be more tailored to knowledge and each specific legal matter. You will be gaining more and more experience, and it will definitely enhance your skill. So, standard of competence. Lawyer must perform all legal services on client's behalf to standard of a competent lawyer. Duty to provide quality of service. So as per 3.2, a lawyer has a duty to provide all these numbers model code you will have to mention in exam as it is whenever there will be a case on a proposition on quality of service. So what kind of quality? So your service should be courteous, thorough, prompt. Your work should be done effectively. This service must be competent, timely, conscious, diligent, efficient, and civil. So, for example, a lawyer has a hearing date. A lawyer cannot tell the client that, okay, I slept, I forgot to wake up and go to the court. So, no, this is a big, big no. This is not a quality service that a client expects from a lawyer. Fiduciary duty of loyalty. So, R versus Steele, again, this case we have already discussed. You can mention this case again here. Then legal angles on lawyer's incompetence. So lawyer malpractice, negligence, as I told you, the lawyer doesn't wake up at the time of hearing, so on the day of hearing. So these are not the kind of things that we expect from a lawyer. So Central Trust Company versus Refuse, reasonably competent solicitor, standard of care, was discussed in this case. Then model code provision, competence and quality of service comes into picture. Then another case, Nova Scotia Barrister Society versus Rishi. In this case, it was founded that incompetence based on consistent pattern of poor act, then incompetence was specific to certain facts and time. Good lawyering in some cases does not excuse incompetent in other. This is important to note. No matter you have done good lawyering in some cases and in few you made blunders, so that blunders cannot be ignored because you have a past of good lawyering. No, every case is important to you. No matter you fail, no matter you lose or win the case, that is a secondary thing. Your homework should be perfect. Law Society of Alberta versus Sayed. Allegations was failing to serve a client diligently and efficiently. Admission, Sayed admitted to lapses but claimed they fell short of incompetence. So outcome was there was reprimand based. So next is cultural competence. So basically this topic will be discussing in detail in last topic of equity, diversity and inclusion. But here you can refer to this case which will explain to you this concept in a better manner. So in R versus Fraser, what happened was applicants concerned about an all-white jury were not addressed by his lawyer. So Court of Appeal ruling appellant entitled to new trial. So if a client demands some specifications regarding language or there is an all-white jury, then it's the duty of a lawyer to perform reasonable standard, not perfection. Then it's important that in order to maintain cultural competence, a lawyer should include people from diverse background. So even in case here, the lawyer did not address the client's concern about all white jury. So here it was lawyer's mistake. He did not follow cultural competence. He did not respected the culture, the demand of his client. So mental health and diminished capacity, balancing client autonomy with lawyer's perception of the client's best interest. Then there should be some mandatory programs ensuring lawyers keeping up with development and changes in legal system. Then rule 3.22 of model code requires lawyer to be honest, candid in advising and representing clients. So these all are quality of service. Then Law Society of Manitoba versus Savino, what came out from this case? So an important observation came out. No one is better qualified to say what constitutes professional misconduct than a group of practicing barristers who are themselves subject to rule established by the governing body. So it says that if a law society has prepared some rules, there are some code of rules, then that's the best thing that a lawyer should follow, because those rules, those codes are made by persons who are themselves barrister, so they better know what is a professional misconduct. So quality of legal services, generally we expect lawyers must provide their services that command public confidence. So integrity, high standards should be there. Model code 3.2 is there. Then lawyers must attend to matter promptly, meet deadline. As I told you that a lawyer did not go to the hearing, he was sleeping or went to some family function and did not inform the client. So these are the things that shows whether you have performed quality of service or not. So what are the expected practices from a lawyer under quality of service as per commentary 5? Client communication, keeping clients reasonably informed, time to time, information request, answering reasonable client request for information, responding to client call, keeping appointment, taking step to fulfill promise, ensure instruction and writing, confirm in writing through emails or whatever source or communication mode you feel comfortable with your client. Respond to communication that require reply within reasonable time. Ensure work is done timely to maintain its value to the client. Provide quality work. Adequate facility. Maintain office staff, facility, equipment adequate for practice. Inform, explain settlement proposal. Provide complete, accurate, relevant information about a matter. Make prompt, complete report or interim report when final reports are not possible. Being civil. Avoid the use of intoxicant drugs that interfere with service. So there was a case of Law Society of Ontario versus D. Giacomo. Basically, it involved 84 investor clients, 16 syndicates, 16 real estate projects, all of which failed. So this was misconduct. So lawyer ignored client interest, failed to communicate, did not obtain consent for joint retainer. What was the outcome? So hearing panel rejected 1 year suspension recommendation, emphasis importance of professional discipline and public protection. So in this case, you can see that 84, 16, 16, these many cases all failed. So here we are not talking about if out of 100 cases a lawyer failed in 20 cases, for example. So that happens. That happens usually. It's not a big deal. But if a lawyer is following similar pattern of ignorance, failure to communication, and as a result of that pattern is failing in all 100 cases. So that definitely requires the attention towards conduct of lawyer, towards the services, the kind of services a lawyer is providing. So duty of candor. What does the word candor means? So simply it means frankness, the quality of being open and honest with your client specifically. So candor word you should understand, keep in mind frank. So now I think most of the things have already been clear when I told you the English meaning. So lawyers must be honest, candid when advising client, inform client of all relevant information, provide competent, candid opinion on merits and probable outcome. So there was a case of Strother. Lawyer failed to disclose financial interest in a potential competitor. So BC Court of Appeal upheld the finding of professional misconduct for not advising the client to reconsider previous legal advice. So there was another case of McCurcher. Lawyer failed to inform CN about existing retainer with another client. So there was an already ongoing agreement retainer with another client. So there is a duty of candor, frankness, openness that require duty of loyalty along with avoiding conflict and commitment to client's cause. So then Law Society of Alberta versus Schuster. Lawyer failed to inform the client of $3 lakh error in depositing fund. So Alberta Court of Appeal upheld the finding that error should have been disclosed as it was important, it was material. So what does duty of candor require? Client communication, honesty, integrity, professional courtesy, good faith in dealings. 7.2 Rule 1 talks about this. Admission, conduct and discipline. So professional conduct and discipline. Canadian Bar Association initially adopted the canons of law ethics in 1920. These were not exhaustive but aimed to promote ethical standards. Then in 1974, what happened? A new code came with 17 fundamental principles which encouraged lawyers to follow ethical standards. Then in 2009, CB and FLC released comprehensive code in which there were details about lawyers' ethic, which we call model code. So these are the things that regulate the professional conduct of a lawyer. So, anatomy of lawyers' code. So, lawyers must act honorably, competently, avoid conflict. So, this is the gist, the conclusion of these codes. So, then next, these include maintaining public confidence in profession, ensuring legal services are widely available, addressing issues like equal opportunity and sexual harassment. So, now comes the concept of discipline. So discipline concept as it is time and again comes in one or the other question, definitely in exam. So this is important. Canadian law societies can discipline member for professional misconduct or conduct unbecoming a barrister or solicitor. Discipline serves to protect the public interest, deter the lawyer from breaching professional standard. So whenever there is a question of breaching professional standard, professional misconduct, the examiner might ask you whether disciplinary proceedings can be initiated. So you have to decide yes or no. Disciplinary proceeding divided into three stages. First is investigative, begins with a complaint, often from a client, then hearing before a panel, then penalty, where you have to decide whether you have to disbar the lawyer, there is a right of appeal. Then comes unauthorized practice. Unauthorized means which you are not legally allowed to do. So general prohibition. So this protect lawyers' profession monopoly in providing legal services, ensuring confidentiality, privilege, liability, insurance, compensation fund. So provincial laws like we have Legal Profession Act, Law Society Act, these criminalize, penalize, they have punishments for unauthorized practice. Like Law Society Act Section 51, it says that only licensed member can act or represent themselves as barrister or solicitor. If anyone else does, then they will be fined or they will be sent to jail. But there are exceptions. A person, individual can represent themselves in legal proceeding under self-representation through authorized agents or through articling students under supervised principal lawyers. Then we have paralegal, especially we talk about Ontario. Then we have Ontario's Access to Justice Act 2006. Their paralegals can represent clients in small claims court, provincial board, highway traffic cases. So, but this include licensing, education, insurance under Law Society of Ontario. So the first paralegal licenses were issued in 2008. No other provinces adopted similar regulation. This you have to keep in mind. So next is what about language right? So Model Code of Professional Conduct outlines specific rules, commentaries which govern the language rights of client, ensuring their rights are respected, protected in legal proceeding. So what are these rules? So rule number 3.22a and 2b, they say that it is the duty of a lawyer that whenever a lawyer find appropriate, required, advise a client of client's language right. That in some cases a client might feel nervous or whatever, so it's the duty of lawyer to make sure that his client knows that the client is having a right to proceed in the official language of client's choice. So if a client wishes to retain a lawyer for representation in the official language of client's choice, a lawyer must not undertake the matter unless that lawyer is competent to provide services in that language. For example, I am a lawyer. I only know two languages, English and French. There is a client who wants me to represent in Chinese. So here, if even if I have like basic Chinese knowledge, but I am not 100% competent, or I cannot conversate properly, or I cannot put forth the advocacy properly before the court in Chinese language, then I should refrain myself. I should straight away tell client that okay, sorry, you have to find some other representation for yourself because I am not competent enough to take further the proceeding in the language that you are requiring me to take up. So here you should not think about profit motive that okay, the client fees will go or something like that. This is the main rule that you have to follow. Firstly, number one, advise a client that the client has language right and they can proceed in their official language. Secondly, if the client require you to represent in the official language and you are not competent enough, then you straight away tell the client and you must not undertake the matter further. So these rules commentary says that prompt advice. A lawyer should advise the client of the language right as soon as possible in the very early stages of the legal process. Then it would be the client's choice. The choice of official language is always solely individually completely of the client, not the lawyer. A lawyer cannot force a client to accept the fact that okay, I'm going to represent in this language only. Does not matter you want me to represent in some other language. So lawyer cannot do that. So lawyer has to respect the language rights of the client because this is in consonance with Canadian Charter of Rights and Freedom section 19(1), then part 17 of Criminal Code, then provincial or territorial legislations. Many provincial territorial legislations provide additional language rights, including those related to aboriginal languages. So as I told you earlier that if as a lawyer you are ready to take the client's case in the demanded language, then before undertaking to represent the client in the language of client's choice, a lawyer must consider whether they can render service competently in that language. So this is in accordance with Rule 3.12 and its related commentary. Now there is a case which is related to language rights, Law Society of New Brunswick versus Ryan, 2003. So basically this emphasized the role of law society in maintaining a professional standard, protecting the public interest, reinforcing the need for lawyer to adhere to follow language rights as part of their duty. So language right, following language right is a part of a lawyer's. So last concept is related to equity, diversity, inclusion. The moment I landed in Canada almost 2 years back, this term EDI, I have been reading, seeing, studying almost everywhere. So if you are a part of Canadian society, remember EDI, equity, diversity, inclusion is one of the most important concepts. So regarding clients and legal profession, what does this mean? Legal profession EDI focus on ensuring fair access to legal services for individuals no matter what culture you have, which race you have, which gender background you come from. Regardless of all these things, everyone deserves fair access to legal services. Everyone has right to get represented in court of law. It encompasses efforts to create an inclusive justice system where clients from diverse backgrounds have equal access to legal representation. Does not matter that you are an Indian lawyer and you are only representing the Asian community people. No. As a lawyer, you have to take up client from every diverse background. Every client should be equal to you. Professional requirement. So lawyers are encouraged to engage in community activities, promote diversity, respect for different culture. This include exhibiting cultural competence, incorporating principles of EDI into their practice. Even the model code, although it may not have specifically mentioned anything about EDI, but many law societies have introduced few important rules related to EDI in their model codes. For example, if we talk about Law Society of Ontario, previously required licenses have to submit individual statement of principles where they state that how they are gonna promote diversity and inclusion. So firstly, as I told you, equity, what does it mean? It means there should be a substantive equality. Lawyers must ensure that their conduct toward clients is such that it should not discriminate anyone based on any ground like sex, race, ethnicity, disability. Also provide extra support if you think some person is vulnerable. Then inclusion, be open to everyone, bring cultural competence in your profession, diversity as a measure. So diversity means diverse people, different communities. So a lawyer's clientele should always be diverse. So goal of diversity means that The representation of clients is increasing. You are taking clients from disadvantaged groups and you are ultimately achieving this substantive equality. So your whole principle, if you tomorrow gonna have clients from indigenous background, then few Asian community, few other communities, so then what will happen? Your clientage will increase. You will be making a cultural competence in the society. You will be following the principle of inclusion, as you will be open to all kind of people, and ultimately what you are bringing in your profession, you are setting an example of substantive equality. So this important concept you can also relate with access to justice. That is the last topic under this subject. So rest I'll be teaching you when we'll be writing answers, how you can relate one topic with the other. But here just keep this in mind. So with this we are ending our first lecture. So that's all about today's lecture. I hope all concepts would have gotten clear. Even if you have any other doubt, you want to enroll in this course, feel free to reach out on demystifycanadianlaw@gmail.com, or you can follow me on Instagram page, Jury's Journey, NCA Triumph and Canadian Law. You can send me DM there. I will add you to common WhatsApp group as well, where I usually send additional complimentary material from time and again, all the updates I share there. Also, please do subscribe to my channel. Keep supporting. Thank you and good luck.